welcome everyone to the third panel of today. In this panel, we are going to have 4 papers, very interesting papers, and the panel is focusing on computational empowerment and legal dilemmas. I think we are going to continue with the conversation or the discussion we had in the previous panel, especially with regards to how the Bulgarian government and society is seeing the affirmative action program. What are the discussions about? So I think Sina is going to present about that. We are going also to hear more about different forms of exclusion and the conceptualization of equality. So very, very interesting papers, and also maybe a very dear to my heart topic, the affirmative action program in Romania and the education in Romani language. So on my left, I have Zsuzsa, who is going to be our discussant for today. She's a research fellow at the Institute for Democracy. And I think I'm going to start with Milena, the presentations. Milena is a doctoral student at ABO. At ABO University, and she has been investigating ways towards interfaith dialogue and the daily life of religious minorities in school in Finland. You can read about the bios of our speakers in the booklet. So Milena, you have the floor, 15 minutes.
Okay, thank you. So I'm really happy to be here. It's a great honor to speak to you all, and I hope I can contribute with something. I will try to speak shortly. So the name of my paper is Resisting Exclusion Inside Egalitarian Schools. So Finnish schools can be said to be egalitarian. Mostly kids go to their closest school, and the school is free and they get free lunch. Anyway, it's not so easy to be inside this school for children who belong to minorities. And I have done this sort of in-depth interviews with religious minorities in Finland, teachers and families, about 30 persons, and talked to them about how they shared narratives about their daily life and how they experience this. And now I also started to take in some narratives from the Roma minority. I'm not going to explain here why I chose the Roma minority. You can read about it in the paper because it will take too long time. But this is what I'm doing, and I think this is the first project about such project in Finland, because more normally people look just into one minority and how it feels, but this is like comparative approach. And I would like to underline that I look at these schools, Finnish schools, very much from the angle of Kimlikka. So this very nationalistic project discourse that is still alive in the school because of history. And these minorities are inside this school. And and as method, I'm looking into, or I'm using counter storytelling that comes from critical race theory, and it's about the own voices of minorities. So now let's see if this changed. Yes. So first of all, I really want to honor these people because I have collected the narratives from the faith minorities, but these two great researchers, they have collected the narratives from the Roma persons inside Finnish schools. So it's Marko Stenros, he's a very famous Finnish scholar, and also Jenni Helakorpi at Helsinki University. And then I have also used narratives that were from a report, a project. And here is a picture, lots of people in this project. Those Finnish white people and Finnish Roma people. Yeah, so also, you know that there is this framework convention for the protection of national minorities. So it's also signed by Finland. So these minorities are under these protections. So you can see it's like Jews, Tatars, Karelians, Old Russians, Sami, Romani, and Swedes. And actually, you can see that there is some sort of crossing with the faith minorities. So the faith minorities that I'm looking into are Jews, Muslims, Catholic Christians, and Orthodox Christians. And all these three, like Jews, Muslims, and Orthodox Christians, are quite connected also to these national minorities. But there is a big difference between these two groups. So even if you have this sort of officially, the framework convention, if you look into schools and what is happening, the minorities are not having any sort of affirmative rights based on this framework. That would work really systematically on the whole national level. That is not there. But the religious minorities, they do have it, because Finland is like Austria in this sense. So there is this opportunity to get own religious education in school, and you have an own teacher and you have your own group. So the group comes together normally once a week. So this is a difference. And when we look into the Romani, the Roma people and their narratives, and compare them with the faith minorities, this is a difference to keep in mind. Okay. These are the only narratives I have time to share here, but they are important. So the first one is from a Romani assistant teacher. And what she is saying, what is happening is that the children in the class, they should count how many adults do we have in the classroom. And the children, or the child who is asked to do this says, oh, there are 3 children. And then the teacher says, the white teacher, Finnish teacher says, no, count the adults, 3, no, count the adults, 4. The student notices me, so this is told by this Roma assistant teacher. Maybe I do not sort of count. That is her reflection that she's sharing with this researcher, Hella Korpi. And I think that this is something about being inside this school that is heavily dominated by the nationalistic discourse, that the children have some sort of feeling for who should be counted and who should not be, and they feel a bit uncomfortable. What is this person? She's not maybe a real person because she's here as a Romani person, and what should we do with her? So this is the result of it. And then we have this other story that is from a faith minority teacher, because as there are these affirmative measures that make it possible to have own groups, it means that there are teachers with academic education. So they are also very much telling, when I talk to them, they talk too much about that they should be invisible, they should not be seen. And also the items of their religious books and so on, they could not leave them in the class. And this teacher, she found out to transform this prohibition into a game. And the children hid their books in high places. And the next lesson began with the children climbing to retrieve their items, checking their presence. So what we can see is that it is sort of the same oppression. This oppression is very much alike, that you should not be seen, you should be invisible in some way. But the reaction is a bit different, because this person who is a teacher, she has the own space. She's sort of the queen of her classroom with her group. So she can transform it into a game. She can do something out of this oppressive situation. While the other person, the Romani assistant teacher, she cannot do it because she doesn't have this power position in the classroom. And it also means a lot because these children are watching what is happening. So yeah, they see that the Romani adult person is not counted. And also for the rest, but I will not repeat because we got these reports already about Roma students there are slurs, there is diminishing, there is this all. I have written an article about exclusion of religious minorities, very much the same. So it seems that this is sort of the functioning of the dominating group, that it very easily becomes negative and oppressive, and it can target many different minorities. And then what more about these, that when the religious minorities have support from the law, they have this affirmative measure that gives them the chance to have some own teachers, own classes, and so on. It also was a difference when they were telling their stories, they shared their narratives, because they were able to do activities inside the school that even brought them forth and gave them some space, and they could gain some visibility. So these actions that they were allowed to make in a positive way, it was about art, festivities, and creativity. So it's very interesting that that was different. It was different in a way that when you made it through these sort of more creative actions, it was allowed and it was even welcomed, and it was successful. But the Romani narratives didn't contain this, except for in one project, and this was the Tsetanenal project in Tampere. And what is very interesting there is that the person who was sharing the stories, he was a mediator, a Romani mediator, and he was not situated only inside the school, but he had a quite strong position in the municipality, and also supported by the EU project he was working with. And they had lots of activities outside school, also creative activities, sports, and so on. And the students really liked it. And also all these children who took part in this project, they successfully ended school, these Roma kids. But it's very important, I think, to underline that the Roma persons who were situated only inside the school, they couldn't do this because it was too oppressive. The system was oppressive. So, yeah, to wrap up this whole thing is that also in Hungary, I read a report about the project where they had been for Romani youth using art, contemporary art, and it had been very successful. So on one hand, what I want to conclude is that art, creativity, it can be a source to give visibility, to gain space, and also to have dialogue. Like, okay, I come from religious studies, so we speak about interfaith dialogue, but it can be intercultural dialogue and cultural heritage. It can be strong and good ways to make children feel better and make the community more aware of diversity and different groups in a good way. But if you don't have any legal protection, you will not sort of advance, because the system is so, I think, at least this is from Finland, it's so heavily sort of important for the national state to have this national school with a national holy one language, one idea, that it's a huge discussion sort of to change this. If we talk about that, it will take a long time for Roma minority or for other minorities to become strong and come out from this vulnerable position. How long will it not take for the dominating group to become more liberated from the idea of this only one nation state to be the best project ever? So the legal protection is very important, and that it is on a national level, because the municipalities, they tend to play their own game. I think this has been seen by many researchers all over Europe, that even if you have good state projects on the municipal level, it's very hard to get them implemented. So this was more or less. I will finish a bit earlier, more time for talking. Thank you very much.
Our next presenter is going to be Zsuzsa Plainer. Zsuzsa is a sociologist and anthropologist from Romania, Cluj-Napoca, and she's a researcher at the Romanian Institute for Researching National Minorities. Zsuzsa is going to present her paper on the issue of university places for Roma and the Romani Language Teachers Program in Romania. Zsuzsa, you have the floor.
Thank you. Thank you. Do you hear me?
Yes.
Yes.
Okay, thank you very much. So I represent some aspects from which are actually missing from my paper, so please take it as such. These are some complementary ones. So what is the topic? The topic is the analysis of the special places, special university places for Roma students in Romania within the context of educational mobility. The research questions are as follows. Were these Roma places successful in facilitating educational mobility? Do these Roma places contribute in the creation or reproduction of the ethnic glass ceiling? Here, of course, I'm following Dust and Zsanna Nyíru. Are these hidden barriers which put the educationally mobile Roma into racialized niches of the labor market that are created to meet the needs of the Roma in public services, ethnic organizations, and so on and so forth? Or the other way around, is this educational program a protective factor which mitigates the price of mobility and helps the process of ascension? Of course, here I'm following many fellow researchers, for instance, like Boros, Bogdan, and Dust, of course. And they say that Roma charitable foundations, ethnic supportive programs have to endow its beneficiaries with Roma cultural capital necessary for the first-in-family persons to succeed in graduating higher education and find a position in the labor market. So which one? As concerns the research, it is made of 24 narrative interviews carried on with all first-in-family university students and the graduates who declare themselves as Roma. 20 of them are university graduates, 10 graduated under special places, 10 were not beneficiaries of the special places, and 4 persons were students in the time of the fieldwork. The interlocutors came from different Roma sub-ethnic groups. Majority of them are assimilated towards the Hungarian or the Romanian society in Romania. Others come from more traditional Roma groups, just like Gábor's on Vatrás. What are these Roma places, special university places in Romania? It has been started in 1992 at the initiative of some sociologists and Roma activists. As a result, 10 places were allocated for Roma students at the specialization of social work and sociology in Bucharest and Cluj. Later, a new specialization appeared, that of Romani language teachers. In 1998 and 1999, the project was taken over by the state. A legal framework guaranteed the allocation of the places in all Romanian state universities and for a variety of specialization. The number of the beneficiaries was the highest in 2017, when it was 618. The lowest number of students was in 2021, when there were only 2,086 persons enrolled in the program. Aim of the program is the creation of a Roma elite who ideally would return in the Roma communities to develop them, the communities. What are the specificities of the program? And I think this is very important. First of all, the candidates are required to have a certificate on their Roma ethno-racial identity, which certificate is actually issued either by Roma parties or by Roma NGOs. I did not introduce in the paper, but I think it was to be discussed. It is a very, very controversial issue. How do we actually certify identity based on the official certification? Anyway, I will include this in the final paper, but it's very important to mention this. And the second issue that it is still an affirmative action, as the candidates compete only among themselves for these places, and they are exempted for tuition fee during the all 3 years of studies. Of course, this program was extended to the MA level, to the PhD level, and so on and so forth recently. As concerns the findings, the first question, were the special places facilitating educational mobility? To some extent, we say yes, because there is a group to whom the places were necessary and important. In many cases, they were not so high achievers or had no material resources to pay tuition fee. Many of them, majority of them, became the members of the new Roma elite. They are NGO leaders, Roma experts in local councils, and many of them Romani language teachers in schools. Was it a glass ceiling for this case, for this category? It is very difficult to find out, because for them, the experience of mobility is very, very positive. They perceive mobility as a success, even though they work in these niches of the labor market. It's very important to understand that in their cases, the Roma places were accompanied by other resources, material ones, symbolical ones. These were allocated occasionally by the designers of the program, local university teachers, or other agents. Let me quote from an interview, which I think is very relevant. Those who manage the special places helped me to participate in many programs, either by Soros or Open Society Institute and many other NGOs that had projects for Roma community development. Initially, we participated as volunteers. Later, we obtained an REF scholarship, and later we worked for money. This is how I learned to do the job in social assistance, which helped me to find a workplace. It is an interview with a person who works as a local council expert on Roma problems. And again, we say yes, because the program facilitated the ascension in the cases when these NGOs who issued a certificate on ethno-racial identity asked volunteer work in return. It later turned into paid jobs and endowed the persons with professional capital, which helped them to find a job outside the racialized niche of the labor market. And it's also noteworthy that many graduates regarded these special places only a self-entrance to university, especially for the tuition fee exemption. They had no connections with the Roma emancipation movement ever since. Their ascension was facilitated by other factors, for instance, non-Roma religious groups or others. So they just used this possibility. They entered the university and they had nothing to do with this whole process of identity making or Roma emancipation movement. And the second question, do the special places reproduce the ethnic ceiling, ethnic glass ceiling, or racial glass ceiling? Yes, of course, we have plenty of examples. For instance, one respondent had chosen the specialization in Romani language and culture instead of Orthodox theology, as he was strongly discouraged by the local priest. He lived in that time in a very small village. According to this priest's advice, the church, the Orthodox Church, pays attention, here I quote, to racial issues, and the Roma priest would not be welcomed in the clergy. In other cases, some had chosen many to teach as unqualified teachers in Roma-only schools instead of competing for a job as a qualified high school teachers according to their university specialization. In their interpretation, there are no places for high school teachers in that given town. And here, let me drop to the conclusions. The places themselves, in my opinion, the places themselves facilitate educational mobility if the candidate is a low achiever, mainly because of its marginal conditions, or has no material resources to pay the tuition fee. But it's very, very important to understand that not the places are successful, not the project itself is successful, but the resources which are allocated to them. These material and symbolical advantages are not in the official description of the program. So the law guarantees nothing but the places, nothing at all. These resources come actually accidentally, and they are managed by other agents. This case is very similar to those university graduates who were not beneficiaries of the local special places. So here we find a very similar structure, and it has nothing to do again with this educational program. And this is my third conclusion, and here I will finish, that the experience of mobility has no connection with the special places. We find plenty of examples when the beneficiaries feel themselves very contented, and there are other examples when they don't feel themselves so very contented. The experiences are ambiguous, but it has nothing to do with their position, whether they were beneficiaries of these special places or not. It depends, I mean, the success and the experience of mobility depends on the present experience of the interlocutor and not the structure he was actually or she was actually part of. Structure by structure, I mean, in this case, these particular university places. Thank you for attention.
Thank you very much, Zsuzsa. Our next presenter is going to be Sina Van de Bogaert. I'm very happy that I can see your paper progress, Sina. We have been in contact for the last few months. So I'm very curious. So Sina is a member of the European Commission Legal Service and a visiting professor at Mannheim University, where she teaches EU fundamental rights. And her paper is going to focus on ethnic quota in higher education, positive action, tackling structural discrimination or unjustified differential treatment. Sina, you have the floor.
Thank you so much, Simona. Let me see if I can make this work. I'm technically very bad with these kind of things. So can you see my screen?
Yes.
Yes, and I would like this to be a new, because now you see my slides not in the way I want you to see them. Let me check if I can move this. No, I want to start presenting. Just a second, please.
At the bottom.
Yes, at the bottom, tell me where.
Yes, you are close to that. It's a screen sign. Right.
Oh, yes. Lovely. Can you now still see it? No, you don't see it anymore because
Not yet.
Push it again.
okay.
Share the screen.
Yeah.
Yes, I did that,
Yeah.
but the thing is, I have two screens, and it comes on my left one. I wanted actually to move this taskbar so I can go into the PowerPoint. Ah, voilà. No, it comes on my, yes. You see it now, don't you? No, you still see it in the other form.
Yeah,
Ah, voilà. Well, okay. We'll just go like this. Voila.
Yes.
Thank you for having me with you, even though not in person, but from a distance. And I'm glad to bring in a more legal perspective into the discussion, because I will approach my research question purely through the prism of the law. The research question basically is, where is the delineation between what makes ethnic quota in secondary or higher education legal? So in this particular case, a case of positive action, which is allowed by the existing European legal framework, and what makes that a certain measure or quota, which is based on race and ethnic origin, is a form of illegal discrimination. So where do we draw the line, actually? Where do we draw the line? What criteria does a scholarship scheme, for instance, need to fulfill for it in order to be a positive measure, an example of positive action, and not a means of discrimination? Now, before I start off, it's very important for you to know that I'm speaking here in my capacity as an individual and not as a member of the European Commission's legal service. This is important to state because as an official, I have an obligation to comply with my staff regulations. And I also won't be able to take any questions on ongoing cases, for instance, as I'm not allowed to communicate on that. But I would like to share my own personal views about a case, because this is what prompted me basically to start working on that paper. It's indeed work in progress, as you could see. And I'm very upset with myself that I couldn't progress as much as I wanted. But I will do my best to progress, also based on hopefully the input I will get from you. So what prompted me to start working on this? It's a decision by the Supreme Administrative Court of Bulgaria of the year 2020, whereby that court held that the scholarship scheme which Roma Education Fund started up in Bulgaria in the year 2016 was illegal. And when I read that decision, I wanted to cry, really. I was thinking, this is not happening. The decision, in my personal opinion, is a bad decision because of different aspects, and I will come back to that later, both in terms of outcome, in terms of methodology, legal methodology, and in terms of lack of reasoning. But first of all, let me just paint the overall context. Do you see the next slide? You don't, do you?
Oh, not yet.
Just the first one.
Oh, this is not working. Wait, let me.
Now
I will
Now
stop
it's
share and I will just do it again. Share screen. Here we go. Screen one. Share. Let me do it differently. And now, what do you see now?
background to
A beach.
Yeah, exactly. I don't want you to see the beach. I want you to see my presentation, not the beach. Okay, let's go. Yeah, that's my screensaver, which is a beach. Okay, let me go again. Share screen. Voila.
just wait. Now it's okay.
Yeah, it's the same actually.
It's fine. Outline.
No,
it's
outline.
It's
It's the main PowerPoint.
Yes, but I want you to see the next slide, not just the first.
No, but
It's
this is
the third one. Or second or third one.
This is slide 3.
You see slide 3 now. Okay, that's lovely. You see an outline which says introduction, right?
Yes,
Yes.
yes.
Yes, very well. And now do you see?
Out of the time.
Now you see.
A white. Yeah,
Now you
white
see statistical data on discrimination in education in Bulgaria, right?
Yes.
Yes.
Very well. Okay. So you all know that. I don't have to dwell on that. So I'm referring now to data available in 2016, because 2016 was the year when Roma Education Fund set up the scholarship scheme. So we had back then about 1/3 of Roma which only had completed primary school. Slightly more than 1/3 had only a lower secondary school diploma, and only 6% of Roma had an upper secondary school diploma. And when we compare that data to ethnic Bulgarian children, we see, for instance, in terms of early school leaving, Roma children aged 20-26, only 28% of them had completed secondary education, whereas in the case of ethnic Bulgarian children, it's 95%. So we had a huge educational gap between Roma and non-Roma children, which we still have today. It's slightly smaller, but it still exists. So why was that scholarship scheme by Roma Education Fund controversial, also especially in legal terms? Now, it targeted Roma based on ethnicity. So it says this is a scholarship scheme for Roma. It provided financial support over a period of 10 months. It was merits-based, a minimum GPA of 3.5, which is a pass. So it's not the American GPA, but it's the Bulgarian GPA, which goes from 0 to 6, whereby 3.5 is just a pass. It included mentoring and tutoring, and the aim of the scheme was to reduce early school leaving, because that was a big problem. For instance, in the school year preceding the scheme, there were 2,300 early school leavers, and most of them were Roma. And so the overall aim was to enable young Roma to break out of vicious circle of deprivation and exclusion. Now, what exactly did the differential treatment consist in when we compare to the ethnic Bulgarian children? So the quota, the number of the scholarships, there were 1,200 of which 200 awarded to 9th and 10th graders, €30 a month over 10 months, and 100 awarded to 11th and 12th graders, again, €30 per month for 10 months, provided that all of them have a GPA of at least 3.5. Whereas there was a second scholarship scheme, which was the general scholarship scheme for the entire Bulgarian society, so Roma and non-Roma alike, which was also merits-based, whereby the students scoring excellent got 21 left per month, so about €10, and the students scoring very good got about slightly less than €10 per month, but with the additional precondition that the students had to show a low socioeconomic status, which was not the case for the Roma. Now, as soon as the scheme was announced, there was a public outcry in Bulgarian society. I can share the presentation with you later if you'd like to, so you can read a bit more about it. So there were interviews in the media stating that how is this possible that only the Roma are getting money, Bulgarians are poor too, they should also get the same amount of money. And then an association which was fostering the rights of native Bulgarians brought the case before the Bulgarian Equality Body. And it brought the case against the Mrs. Kuneva, who was back then the Minister for Education, stating that what she's doing is not in line with Bulgarian national law and the Bulgarian Act on Anti-Discrimination, which implements the Racial Equality Directive. So it's Bulgarian national law, which is implementing European law on racial discrimination. And so I won't have time to go into the details of all three layers, of all three instances, but what I do want to note is that the equality body itself, when examining the case, examined the case through the prism of positive action and said, well, this is positive action with a legitimate aim, which is well justified, and we see no problem for this scholarship scheme. And then the case went to the first instance court, the Sofia Administrative Court. And there it was held that the scholarship scheme was discriminatory against ethnic Bulgarians and therefore illegal and had to be done away with. And that case went up then to the last instance, which was the Supreme Administrative Court of Bulgaria in the year 2020. So the proceedings took a while, and that Supreme Administrative Court in Bulgaria confirmed the lower instance judgment, stating that indeed this scheme is illegal in the light of Bulgarian national law and should be discontinued. And now, how was this reasoned? Move this to this side. So if everything is going still well, you should now see a quote from the decision. Can you read it? Can you see it?
Yes.
Yes, very well. So basically, what the Supreme Administrative Court of Bulgaria held in that particular case is that they started off from the fact that education is free of charge in Bulgaria. And because education is free of charge, this project and the implementation of this project, which focuses on Roma only, is not meeting the requirements of Article 7 of the Anti-Discrimination Act, which embodies Article 2.2b of the Racial Equality Directive. I will come back to that article right away and explain what it says. On the nature and objectives of the measure to ensure participations of pupils in secondary education and thus to prevent dropout. And the court holds that it is not necessary and appropriate, this scheme, or it is not the only way to achieve these objectives of preventing school dropout. Because the court says, well, yeah, the reason why Roma are not attending school are complex. They are not only linked to a lack of financial resources, and the measures they refer to are essentially unequal treatment compared with non-Roma pupils who are in a comparable material situation, so who are also poor. And the court notes that the non-Roma should do more to achieve good or excellent success because they have to score 5 or 6 in order to obtain a scholarship, whereas the Roma only need to score 3.5 to obtain a scholarship. And so the court says this is not in line with the objectives set in the Anti-Discrimination Act, which is to prevent discrimination. And it is not in line with the aim of the Racial Equality Directive, which is to protect against all forms of discrimination. So basically summarizing, this is differential treatment. it is not objectively justified, it is discrimination, it should stop, it should cease to exist. Now, it referred to Article 2.2b of the Racial Equality Directive, and Article 2.2b contains a definition of indirect discrimination. Just for you to have this on the radar, direct discrimination occurs when a person is treated less favorably than another is in a compatible situation on racial or ethnic grounds. Direct discrimination can never be objectively justified. When direct discrimination occurs, it is discrimination. Whereas indirect discrimination occurs when an apparently neutral provision puts a person of a racial or ethnic origin at a particular disadvantage, unless, and the unless is the objective justification test, unless the criterion or practice is objectively justified by three things: a legitimate aim, and the means of achieving that aim are proportionate, are appropriate, and necessary. Now, the problem with the qualification, and I will come back to that later, by the court of this as indirect discrimination is that it is completely false. If you qualify this under Article 2 of the Racial Equality Directive, it is a scheme which is based on race and ethnic origin. So unless you're in the scenario of positive measures, this is direct discrimination, not indirect discrimination, which cannot be objectively justified. So methodologically, it doesn't hold. Now, when we go and have a look at how positive action is defined in the Racial Equality Directive, so important for you to know is that we do not speak about affirmative action in Europe. Affirmative action is an American term. It is used in American scholarship and also in American legal acts. We do not use it in Europe. In Europe, we talk about positive action or positive measures. So positive action in the Racial Equality Directive is defined as with a view to ensuring full equality in practice, so substantive equality, the principle of equal treatment shall not prevent, so meaning it allows member states from maintaining or adopting specific measures to prevent or compensate for disadvantages linked to racial or ethnic origin. So we clearly have four elements. The aim is substantive equality. There are specific measures in place which prevent or compensate for disadvantages, and those disadvantages are linked to race or ethnic origin. And so if you're in that scenario, we're not in the scenario of discrimination. I'll come back to this later also. So now, when we assess purely from a legal methodological point of view, how the court assessed this case, well, then the first problem is that it's clearly, if you assume that it is not a positive measure, so you choose either we're in the area of is this a positive measure, yes or no, or we're in the area of is this discrimination, yes or no. So if you assess whether this is discrimination, it should be qualified as direct discrimination, which cannot be objectively justified. So the court finds that this is direct discrimination, but still uses the objective justification test, which you cannot do under the Racial Equality Directive. And then it says, well, okay, there is a legitimate aim. So the scheme is preventing school dropout, but the means of achieving that aim, they are not appropriate, says the court. But it doesn't say why. And it also says they are not necessary. It says there are other means to achieve school dropout, and school dropout is not only linked to financial hardship, but it doesn't say what the other means are or what the other measures are. And for me, a big problem also is that this case, it refers to CGU case law. It refers, for instance, to the Shea case. I don't know if you know that one. It's a case on electricity meters in Bulgaria. So on the height of electricity meters, which was different in areas mainly or predominantly inhabited by Roma. So there, the Bulgarian electricity company put the meters at more than 2 meters height because they didn't want the Roma to tamper with the electricity meters. And here the CGU said, well, this is probably up to the national court, up to the referring court to decide, but this is probably a case of direct discrimination. So basically the case quoted has nothing to do with the legal methodology behind assessing whether the scholarship scheme is legal or illegal. So they quote the wrong case law. What they do not quote is the case law on positive action in the field of gender equality, which actually would have been useful in this particular case. The problem is that we don't have any precedent in the area of ethnic and racial discrimination when it comes to assessing the legality of positive action, but we do have a lot of precedents in the area of gender discrimination. Now, the methodology the CGU, so the Court of Justice, has been using to assess the legality of positive measures is a proportionality test, which is slightly different from the objective justification test. So the objective justification test, if you recall well, is the test which we use to assess whether indirect discrimination amounts to discrimination, yes or no. And the proportionality test is the test which the CGEU uses to assess the legality of positive measures. Now, this concept of proportionality, according to the CGEU, entails three sub-concepts, namely legitimacy, effectiveness, and necessity. So as you can see, quite similar to the objective justification test, but just not exactly the same. And the existing case law is mainly centered on legitimacy, less on effectiveness and necessity. Now, what does the court concretely say on positive action in the area of gender equality? It says, very important for everyone to keep in mind, it should always serve the stated aim, meaning you should state an aim. So if you say, well, we know that these measures are justified, but we should not be justifying them, as something which I heard coming up in previous discussions, for a lawyer, this is a no-go, because that would make that your scheme or whatever you set up is illegal. Because if you don't justify it, you cannot demonstrate what your objective aim is. That's one. And obviously, it should rely on transparent criteria and objective criteria. As the names I am quoting here are names of cases. If you're interested in having the C number, so you can find them in eCuria, I can give that to you later also. What does not pass for the CGEU is when a scheme is merely seeking to redress imbalances for the mere sake of more diversity in society. That will not pass. So proportionality for the CGEU means that it always, or the scheme or the quota always have to remain within the limits of what is appropriate and necessary to achieve the aim in view. So you should not go beyond what is exactly necessary to achieve your aim. And actually, such a proportionality test can and should generate substantive discussions about the effectiveness of positive discrimination. And this is where we need the sociologists. This is where we lawyers need you sociologists to tell us what the cost-benefit analysis is of a certain scheme, whether it is necessary, whether it has been successful in the past, what the reach is of the scheme, what the extent is of the availability of alternative measures, which might not be discriminatory or less discriminatory. So this is not something we lawyers can do, but something for which we lawyers would rely on other specialists in the field. But the discussion has to take place. And in that Bulgarian judgment, it did not take place. There were just merely one-liners stating that it did not happen, but it did not say why it did not happen. So for me, that is what makes that judgment a very bad judgment. Now, the CGEU has obviously rejected preferential treatment, which is automatic and unconditional, or which does not include an objective assessment of all the personal circumstances of the case. So hard quota are always suspect and will most likely not survive the test. Soft quota have been accepted by the CGEU, have been conditionally accepted in tie-break situations. And so basically, purely conceptually, the CGEU treats substantive positive discrimination, or more correctly, substantive positive action, as an exceptional derogation from the principle of formal non-discrimination. So you have the overall principle of non-discrimination, which consists of a prohibition to discriminate directly or indirectly. And then you have on the side a derogation from that principle, which is positive action. But obviously, these derogations always need to remain within the limits of what is appropriate and necessary in order to achieve that particular aim. So in the case of the scholarship scheme, the aim was not only to prevent Roma dropout in secondary education, but also to foster their inclusion. Obviously, that's why we had the mentoring and the tutoring, which went along. And a second precondition, the principle of equal treatment, is to be reconciled with the requirements of the aim pursuit. Now, what conclusions can we draw from the CGEU jurisprudence on positive action in the field of gender equality and from this particular Bulgarian case? Now, my first reaction is, my God, why did that judge not refer? Because actually there is a legal obligation under the Treaty on the Functioning of the European Union for a last instance court, in case there is doubt on the interpretation of EU law, to stay the proceedings and refer the case to the CGEU. So that is what that Bulgarian court should have done. The Bulgarian court obviously was not sure whether to qualify the case under Article 2.2b of the Racial Equality Directive, or whether to qualify the case under Article 5 of the Racial Equality Directive. And in that moment, the court should have said, I don't know, I have my doubts. Let's ask Luxembourg. But they didn't. So what I would recommend, every single one of you who is somehow related in, or involved in strategic litigation, or who has friends involved in strategic litigation, tell them to ask the court to stay the proceedings and refer to the CGU, because we badly need a precedent in this area. We don't have one and we need one. So whenever there is a question on the interpretation of positive action, on the legality of positive action linked to racial equality, tell the court, I want you to stay proceedings and I want you to refer to the CGU. And then at least we will have one precedent which has gone to the CGU, and we will have at least one case on the legality of positive action in the area of racial and ethnic discrimination. Then second, and that's why I'm writing this article, we need more academic research on the delineation between positive action and discrimination. Because the more bad jurisprudence is created at national level, the more misconceptions will arise. So I think it is then up to us academics to set it straight. And a very fair question is, can we just apply the CGU jurisprudence on gender to ethnic origin? There's a lot of parallels. Gender discrimination is also mostly structural in nature, but discrimination based on race and ethnic origin is very often even more structural and even more pervasive in nature, because it has a lot of facets which are interlinked, and it has also a historical nature. And in that sense, one could imagine, I don't know because the case has not been brought to the CGU yet, but one could imagine that perhaps the stance of the CGU in cases of ethnic origin is even more lenient than in case of gender. Question mark. I think what can also be helpful, and you saw that in my draft paper, but I didn't have time yet to work on that. I hope to work on that in the future, is that US experience can be very helpful, because there we have long-standing Supreme Court case law on the matter of legality of quota. What is also important, I think, is training of national judges on the concepts of the Racial Equality Directive, because we see that there are a lot of misconceptions, even at the level of Supreme Courts in different member states. So we need to train judges on what is the definition of direct discrimination, what is the definition of indirect discrimination, what is the definition of positive measures.
Sina, I would like to ask you to wrap up.
Yes, this is my last slide. One more minute. Thank you. Yes, so a very important message to all of you who design positive measures. Please design them in such a way, irrespective of whether you're a state-owned university or a private university. The Racial Equality Directive applies both to the public sector and the private sector. If you design positive measures, design them with the CGU jurisprudence in mind, with the proportionality test in mind, because if somebody challenges it, and it can happen that an organization will at a certain point challenge your quota scheme or your scholarship scheme, make sure you have designed it in such a way that it stands up in court. And then 2 side remarks, which are not legal in nature, but which try somehow to create a bridge between the work you are doing. Awareness raising, obviously, on substantive equality is very important. And this reminds me of something I've been looking into in the context of my doctoral thesis, which you probably know better than I do, this paradox of identity politics. Identity politics, such as scholarship schemes based solely on race and ethnic origin, they can empower marginalized groups because you bring to the fore, you bring to attention their plight and their hardship. But then on the other hand, identity politics can also divide a society. Like here in the case of the Bulgarian society, where there was this public outcry stating, why should the Roma get money and we don't? So it's very double, but it's necessary, I think. I think that these positive measures are very important and necessary, and therefore I was very sad to see that such a bad judgment was a ground for a very good scheme to be discontinued. And that's why I want to write about it. So in case you have questions or feedback, you're most welcome to either call me or contact me, and this is my email address. Thank you so much for your attention.
Very much. So it seems yesterday, I remember Prem was saying that sometimes we don't have to justify why we have all sorts of measures for access to higher education. But when you speak about governmental policies, I think this legal discussion is very important. And I'm very sorry that Sunita is not here in the room. But we look forward for the comments and the questions from the audience. Our last but not least presentation is from Nick van Faals from the University of Leuven. Nick is an MA student from the Cultural Anthropology and Development Studies Department, and he has an interest in human rights, democracies, and ethnic and cultural boundaries. Nick's presentation is about, it's called From Equality of Opportunity Towards Equality of Results, a progressive shift of European Court of Human Rights case law about Roma school segregation in Central Eastern Europe. Nick, we have the floor, 15 minutes, please.
Okay, welcome everyone. Can you hear me?
Yes.
Yes. Can I share my screen also? I made a short presentation.
Yes, you can.
Fine, yeah. We'll check. I think you can see it.
Yes, full screen, if you can.
Yeah, okay, I see.
Good.
It's now full screen, huh?
Yes, all good.
Yeah. Okay, welcome everyone. I'm Nick van Faals, just graduated from Cultural Anthropology from KU Leuven. And I would like to discuss a topic which I discovered during my studies in a course of human rights, you can say. And it is about the progressive shift of the European Court of Human Rights case law about Roma school segregation. So first of all, so what I discovered is I see that the case law changed towards more a focus on the principle of equality of opportunity towards equality of results. And I would like to exemplify that with a few cases. But first of all, so for the introduction, we all know that there is a stereotypical categorization of Roma people and ethnic labeling, which enhance social exclusion. For example, in the case of Aksu versus Turkey, it was what like Roma images used in the publication, like stereotypically you can say, and that was judged by the European Court of Human Rights by no violation, so no prohibition of discrimination, together with the article right to respect for private and family life. So because of the free speech protection, you can say. So this is like an example of those stereotypical categorization. And now I would like to go into school segregation because that's the topic, of course, of the conference. What we see is a lot of I have heard already a lot of it during the conference. There's a lot of inequality. So you see a high proportion of young Roma in European countries of school dropouts, who has lower educational levels, go to low qualitative schools. They are in separate classrooms or in special needs schools. And the legitimization of this segregation is often done by like tests, like psychological and sorry, I cannot pronounce the word very easily. And we test about they have to do like tests, and then it's like that they try to legitimate the selection of for the people to go to the schools. But actually, this is really correlated to socially disadvantaged backgrounds, you can say. Of course, some people, Roma people, they have less opportunities on another background, you can say, to really score high on such tests, for example. And that means like there is like it's not really equal, you can say. Then to the concept of equality. You have like formal equality and substantive equality. In the formal equality, democratic states, they really focus on the they need to focus on equal treatment in comparable situations, and that's often based on the formula of Aristotle. Equal cases must be treated equally, and unequal cases unequally. So that means, so everyone is like equal by law, but what does that really mean? Because what will define that people are the same? And you can also say like not every distinction is discriminatory. Some distinctions are maybe okay to do to get to the same results of people or to get same opportunities for people. Another thing is like, or actually it's related, you can classify people in groups which can be legitimate. Because what we see is like people of different ethnic origins, they are disadvantaged in a lot of cases, and here we are talking about the Roma people, of course. So when you focus on substantive equality, then you go further. You will check further if it's really about equality, like some race-conscious measures could improve the position of disadvantaged groups. And in some cases, you can say that different treatments are okay to get to the same result same outcome based on equality. And so that substantive equality you can do in the case law. You see that they focus on two principles, and one principle is the equality of opportunity, and even a principle which goes a little bit further is based on equality of results. So when you focus on a disadvantaged group, to get to more equality, you can first check focus on the principle of equality of opportunity, which is already a step, you can say, to fight indirect discrimination. But a further step is equality of result. And I checked some. I would just to be clear, equality of opportunity, that means that the people and the individuals will have the same opportunities at the starting point in this case. So for example, when they apply to school, they have the same opportunity to get into that school. Like you can say that like the schools should like really pay attention on the fact that that every individual has the same chance to be accepted in school. But when you check the equality of results, you will check the outcome. So what is really the case in that school? What is the proportion of individuals based on ethnicity? Is that equally distributed? Is that related to the representation in a country? Like, is it like proportional? But then you really check like what is the outcome? How is it in such a school? Not based on if they got the same opportunity or something like that, but what do we see in the school? Okay. So, and I checked some cases, and I have seen like a shift from the first principle to opportunity to more focusing on principle of results. And the first case is DH and others versus Czech Republic in 2006. And there was a case which was about the placement of 27% more Roma children than non-Roma in special schools. And what they did in that school, there was like a neutral psychological test for all children, and they saw that Roma children were less successful. So the result is, okay, there were more Roma children in in the special school. And then the Chamber of European Court of Human Rights just judged this case as no indirect discrimination, because they say, okay, there is a test, and that the test shows, okay, you will have the same opportunity. Everyone has the same opportunity to get accepted to either one school, or to have the chance to go to a special school or just to another school, you can say. Later on, the Grand Chamber said, no, this is a violation of indirect discrimination, because when you check the principle of results, you see that this proportion of Roma children in that special school, that is disproportionate when you check the proportion of the population in the country. It's not in the same line. So this was actually groundbreaking. That's like the European Court of Human Rights at the end. After that, the applicants appealed, because first the chamber said it's no indirect discrimination, but afterwards, after the appealing, it was okay, it is indirect discrimination based on the disproportional amount of Roma children in such a school. When you go further to like even around 7 years further, 7 years later, there are other cases based on this selection of Roman people in special schools, like, for example, Vida and Others versus Greece, and Horvat and Kiss versus Hungary. Those two cases were both on the placement of Roma children in a Roma or special school. And what we see here is that the chamber directly said, okay, it's indirect discrimination because of the disproportionate outcome. Because there were more Roma children in the Roma children in the exclusively Roma school, that's disproportionate. And also the higher amount of Roma children in special schools, that's also disproportionate. So here the chamber directly focused on the indirect discrimination on the principle of results. And this is 7 years later than the first case I discussed. A very recent case is about Zsuzsa versus Hungary, and it was about a refusal of a school transfer request from an almost exclusively Roma children's school to So it was about the refusal of I see a typo here. It should be one S, refusal. That was a refusal of a school transfer request from an exclusively Roma children's school to like a normal school, you can say. And there, the chamber of the European Court of Human Rights even added that the state should focus on measures to end this segregation. So even that the case was about a school transfer request, there was also in the judgment that the state should really focus on positive measures to really stop this segregation. So it was not, it goes even further than the actual case. The actual case was just about the transfer request, but the court went more into this, and the segregation was like more on the agenda to really take measures on that. So to conclude, what you see is there is like a progressive shift, you can say, from first in the beginning, they just focus on the principle of opportunity, and then at the end or it started already during the Grand Chamber of the first case already said it's indirect discrimination based on the principle of results. But the other cases, it was like directly based on principle of results. And in the last case I discussed, there is an extra, okay, segregation should really focus on. So that is like the shift I saw in those cases based on school or about school segregation, and that's what I wanted to share with you. So thank you for listening.
Thank you very much, Nick. I would like to ask now Agnes Kende to provide her comments to the papers. I encourage the audience to prepare questions. Students will have a priority in addressing their questions. So Agnes, please.
Okay, thank you. First of all, thank you for the opportunity. Can you hear me? That I was able to read and listen to these presentations. Sometimes it's so good to get away from our own context, from our own country, and to learn about the same problems, namely the prejudice, the exclusion and discrimination, segregation against Roma in a completely another context, or completely not another context. So, but let me confess that I didn't try to synthesize these papers. However, there are certainly common issues and problems in all four presentations. For example, two of them focus on positive discrimination. One focuses on segregation from a legal point of view, and the Finnish case stands out from the presentations, focusing on the lack of recognition of Roma children in school. So here, let me express a little envy as a Hungarian that we are still fighting to end segregation, and I would be very happy if we could get to the point where children go to school together and fight for positive recognition. But of course, this is also a very important struggle, and I don't want to diminish its importance. And also, I have to confess that I'm not a legal person. I'm a sociologist, so I'm not able to add any comments from a legal point of view. I can add my comments from a sociological point of view. And also, I have to admit that Nick's study was missing from the first draft that I get from the organizers. So I just only noticed yesterday that there is a fourth presentation. So I could read very shortly, and also it was a very short draft of the presentation. So I'm not able to reflect on in a proper way in my short presentation. So let me start my comments and also my gratitude about Milena's Parland study. I found this presentation on the school situation of Finnish Roma children very interesting, especially in the light of the fact that, in contrast to my experience or the Central and Eastern European countries, where the biggest problem is the school segregation of Roma children. In contrast, in Finland, the case is that within the egalitarian Finnish school system, enjoying a so-called happy diversity in the schools, Roma children do not receive special treatment or sufficient recognition of their distinct ethnic identity. I really like the way the paper shows how the Roma have internalized their own otherness within the Finnish majority society, and despite this fact, through arts education, their own voice can be better represented. That's why when you write about the importance of their voices being represented in education, it will be very interesting to know how the parents' attitudes and feelings about this, what they would like for their children, what they think about their children's school. This could be one direction I suggest towards the paper could be developed. Okay, the other very interesting thought that the paper mentions, but is not explored in more depth, is that the Roma are not only seen as a distinct ethnic minority, or not seen enough as a distinct ethnic minority in education, but they are the poor and underachieving children in school. As I understand it from the paper, similarly to Hungary, they are treated with dismissiveness, and their disadvantages are not compensated as they would deserve in a fair education system based on equity. The reasons for this, as ethnic differences are mixed in the minds of the majority with the social situation, which is then interpreted by the system or in the view of the majority of the society as a distinct cultural characteristic or even deficit that cannot be helped or altered. This aspect in paper would be worth elaborating further, because I think it was a very interesting point what you mentioned in your paper. So let's talk about a little bit about the next presentation. Zsuzsa Plainer's paper examines the impact of the reserved university places for Roma students in Romania. As it appears in the paper, the aim of allocating these affirmative places was the creation of a Roma elite who ideally would return in the Roma communities to develop them. This idea would alone be a good enough topic to be discussed, whether it can be expected from a program to not only guarantee the right of Roma young people to obtain higher education, but it expects them to give back to their communities the knowledge they have acquired. But the paper is much more ambitious than that. I would like to acknowledge the rich literature that discusses social mobility beyond simple class transitions, incorporating factors like identity, family relations, and early educational experiences. Highlights the unique minority culture of mobility among ethnic minorities, which includes strategies to cope with discrimination and disadvantage. However, I would like to note that the questions raised at the beginning of the paper are so ambitious that to answer just one of them would be enough to constitute the subject of this paper. So this leaves the reader with the feeling that although the paper was very substantial and interesting, it wasn't possible to obtain thorough answers to so many of the questions asked. So the third paper, Sina Van de Bogaert, I really hope that I pronounce correctly, paper also deals with a very interesting case. The paper analyzes the legal methodology applied by Bulgarian national courts in cases regarding the legality of positive measures for Roma in higher education. In 2016, a scholarship scheme for Roma high school students was introduced in Bulgaria by the Roma Education Fund and the Bulgarian Ministry of Education, but finally, the Supreme Administrative Court upheld the decision that the scholarship scheme was discriminatory. The paper I read look like a draft version, so my comments may not be relevant as certain sections may be written in more detail later. If this is the case and the direction may still evolve, it would be interesting to present. Now I learned that it's not affirmative action, but positive measures, debate in a more detail. This is a hot topic anyway, given the US Supreme Court decision, as you also mentioned in your presentation, that to ban affirmative action on the basis of race. At the same time, I would also examine possible solutions. There have been many good and also bad practices for affirmative or positive action policies over the last couple of decades. Finally, I have a small critical comment. The paper says that one of the most severe consequences of prolonged segregation, discrimination, poverty, and social exclusion is the development of learned helplessness, the belief that no individual effort would change the personal or family situation. This partly explains why in many families from vulnerable ethnic groups, parents see no point in investing money and time in children's education. Me, personally, I would perhaps put it more subtly here and less psychologically. My research experience is that as these families get into a better social situation, they become more secure in their livelihoods and they don't have to struggle for a daily meal. They become immediately interested in school. At least that is what we see in the Hungarian context. So maybe I would put it a little differently in the terms of causality. And finally, the last presentation, what I wasn't able to read properly, and also I just learned yesterday that it exists. So Nick's paper examines the prevalent issue of educational segregation among Roma people in Central and Eastern Europe and its impact on social inclusion. Over recent decades, the European Court of Human Rights has shifted its case law interpretation on school segregation of Roma people from a focus on equality of opportunity to emphasizing equality of outcomes, which is extremely interesting, especially for me. And this shift aims to ensure more equitable access to education, although more guidance for local authorities is needed to implement substantial changes in non-discrimination practices. The paper concludes that despite some successful judgments, significant work remains to implement effective proactive measures to combat and indirect discrimination and achieve real change at the local and national levels. So at this point, as I mentioned earlier, it would be very difficult to raise any questions and comments, but after your presentation, if you want to further elaborate this paper, the topic of implementation would be very interesting to analyze in depth what works and why, and what doesn't work and why. Thank you very much.
Thank you very much, Agnes, for your comments. Now I would like to invite the audience for questions and comments, and then I'll give the floor to the presenters to respond. But first, questions, comments. As I said, the students have priority.
I have one question.
Introduce yourself.
Yeah, thank you. Do ethnic quotas in higher education help to fight with discrimination, or they create unfair advantages?
So is that the question addressed to somebody specifically?
Yeah, I think Sina.
Okay, good. And Jan?
Okay, very short question then to Milena. I have other comments, but we can take them separately. Is there something right for mother tongue education in Finland? I know that the Roma minority hardly speaks Romanes, but we have in Sweden the rights, and similar cases with Yiddish. Jewish minority children have the right, and there it's treated like a cultural heritage. And this is a space where also talked about identity and things like that, which would be, yeah. So that's a question. Do we have these rights to mother tongue education? And the other, why was there a Romani assistant teacher in the classroom? Does she just happen to be assistant teacher? This assistant teacher happens to be Roma, or what's the philosophy behind that?
Any online participants with the question?
Yeah, yeah. They can raise their hand.
Then maybe we can invite the presenters to respond, and then if we have time, we can take that question. Sina?
Yeah. Well, actually, the question is a bit broad in the sense that I could just now restate the whole presentation I just had in answering that question, because it's very nuanced, the reply to that question. So in some cases, quota will be discriminatory. In other cases, quota will not be discriminatory. So the whole question is, what methodology do we need to use in order to determine whether the quota which are put in place are discriminatory on the one hand, or are positive measures which are an exception to the general principle of non-discrimination? And basically, that's what I tried to do. I tried to point out what tools the CJEU, so the Court of Justice of the European Union in Luxembourg, uses in the field of gender equality to determine whether measures are appropriate or not appropriate. So when you set up a scheme, what you need to take into account is, first question, what is the aim of my scheme? What do I want to achieve with that? And that aim needs to be a legitimate aim. If your aim is, I just want all the Roma to have more money, that's not a legitimate aim. So in that case, your scheme will not be legal. If your aim is, I see that there has been structural discrimination in the area of education, and in this particular country, I have so many percentage of pupils dropping out, which is linked to them being Roma, and I feel that I can achieve less Roma dropout and a better access to quality education for these Roma children, in that I provide them with a scholarship scheme which is merits-based, so which is based on objective criteria. And if I can show that, for instance, research has been done in this field, or that several other schemes in other member states with similar statistical data have been successful, then it is very likely that my scheme will be legal, because then I will have A, a legitimate aim, B, the measures which I am putting in place are proportionate. So I'm giving them a certain amount of money which will be sufficient to reach that aim. I'm not giving them 2,000 euros, right? I'm giving them 30 euros per month. And C, I'm also doing something for the Bulgarians. So the Bulgarians also get money, those who are also in a poverty situation. They are at a disadvantage because they need to score more. For instance, a scheme which says all the Roma will get money irrespective of what their academic outcome is, that might be more problematic than a scheme which says only those Roma get money if they have a certain minimum level of academic proficiency, because the Bulgarians also need to show academic proficiency. And then the question is it legal to ask or to request a different level of academic proficiency for Roma compared to non-ethnic Roma? And then one could say, well, in the case of the Roma, it is more difficult to obtain good results because they are not proficient in the language, in the majority language, because they don't have the same homework support at home as the Bulgarian children do, and because they come from a different cultural setting. So in general, they score worse than ethnic Bulgarian children in education because of all these different factors which play along. And the poverty factor, the factor that they are not as proficient in the majority language as the Bulgarian children are, the fact that they have less homework support, etc. So in those cases, you can objectively justify why you request a lower GPA from Roma children than you require from Bulgarian children. And so if you can objectively justify all of that, then your scheme is more likely to be legal than to be illegal. I don't know if that answers the question.
Yeah, I would like you to try to be short in your comments and answers. Maybe I can ask Zsuzsa if you have any response to the comments. You didn't have a question, but any comments? Reactions? No? Nick, anything from your side? Final comments? Okay, then Milena.
Okay. So the question about the mother tongue, yes, there is, but it depends on the municipality. So basically the states give money for it, and the municipality can choose to apply for the money. If they apply for the money, they are obliged to give the tuition. But if they don't apply, they do not have to do it. So it's not on the national level as it is for the tuition. The legal system is much more vague. I don't know how it works in Sweden, but we can discuss that afterwards. And what was the other question?
Was about this teacher, assistant teacher.
Yeah, I apologize for maybe being a bit stressed and short. So yeah, there was a project, a project getting finance for a short time.
So there was an idea that there is a purpose that we have a Roma assistant teacher in the classroom,
it was a whole project.
Probably there is a Roma people.
Yeah, okay. It was a whole project, and this was in 2013, and then I made the other one in 2017, and then they had this sort of mediators, and they had a better position because this first experiment turned out showing that it was not enough to happen there because the hierarchy in the schools is very, very
That would be
sharp.
interesting to read more about, to develop what was the idea behind this and what was the outcome of this. I'm very interested in that because we have similar discussions in Sweden, and it is controversial argument from both ways.
Yeah. Okay.
Thank you very much. We are running 1 minute late. I hope that's fine. I would like to thank all the presenters and all the audience. Thank you very much, and let's go for lunch.
Yeah. Thank you.